Today's meeting continues a series of expert webinars jointly organized for over a year now by the Foundation Sunflowers and the Kraków Center for International Criminal Justice at the Jagiellonian University. Recordings of all previous webinars are available on the Project Sunflowers and Kraków Center's websites, and the recording of today's webinar will also be made available there in due course. For those joining us for the first time, my name is Ewa Hofmańska and I represent the Foundation Sunflowers that implements Project Sunflowers. I'm joined by Professor Piotr Hofmański, who leads the Kraków Center and to whom I will shortly give the floor. Today's webinar will focus on cooperation between the International Criminal Court and states. Our distinguished guest is Mr. Osvaldo Zavala Giler, Registrar of the Court, and the discussion will be moderated by Anna Adamska-Galant, whom I warmly welcome. Professor Hofmański will introduce our speaker and moderator in more detail, and with that, I'm pleased to give him the floor. Thank you very much.
Thank you, Eva. Thank you very much. Welcome. My role is very limited. My name is Piotr Hofmański. I'm the director of the Center for International Criminal Justice. And we had the honor to organize this series of seminars, successful seminars, I would say. And today is very extraordinary opportunity to hear from the person who is the best involved in the cooperation matters, the Registrar of the International Criminal Court, Osvaldo Zavala Giler. And he's the person who is with the ICC from the very beginning. In February 2023, the judges of the ICC elected him as a registrar, and he assumed his office on 17 April 2023 for a 5-year mandate. I would like to mention that Mr. Zavala Giler is the first former ICC staff member to assume this function, as well as the first national of Latin American nation to do so. So before being elected registrar, Mr. Giler worked at the court since 2010 in different capacities. He served as a chief of budget section, senior special assistant to the registrar, head of office of the court's liaison office in the United Nations in New York, and special assistant to the registrar. Mr. Giler is also one of the founding members of the ICCQ, the Sexual and Gender Diversity Network at the court. It's also worth to mention that prior to joining the court, Mr. Giler worked as a legal officer, legal advisor, liaison officer in the United Nations for the Coalition for the International Criminal Court from 2006 to 2010, both in New York and in the Hague. He also worked in a law firm in Ecuador from 2000 to 2003, including on cases before the Inter-American Commission of Human Rights. He's graduated as a lawyer from the Universidad Católica de Santiago de Guayaquil, Ecuador, and is a licensed member of the FARO, the Abogados of Ecuador. He also holds a bachelor degree in social and political science from the same university. It's really impressive bio. Thank you very much for joining us, for taking your time. Mr. Registrar D. Osvaldo, it's a great pleasure to have you with us today. And we have invited Dr. Adamska-Galant as a moderator of the meeting today. She's the Polish lawyer with extensive experience as an international judge, in particular in criminal cases. Her research interests focus on the practical aspects of obtaining testimonial evidence in criminal proceedings, international criminal law. For 17 years, she served as a judge in Poland and the Balkans, primarily ruling on criminal cases. From 2013 to 2018, as an international judge within the European Union Rule of Law Mission in Kosovo, she adjudicated, among other cases, war crimes committed during the armed conflicts in the former Yugoslavia. In 2015, she was appointed as a judge of the Supreme Court of Kosovo. And since 2018, she has worked as an independent expert on justice and rule of law for Expertise France, the Council of Europe, and the World Bank. She advises in the process of establishing independent courts in Ukraine, where from 2018 to 2023, she led the judiciary reform component of the European Union Bravo and Justice Ukraine project. In 2021, she was appointed by President Zelensky to the Council of Experts on Judicial Reform. She is an expert in combating human trafficking and human rights violation in the Center of Research of Human Trafficking at the University of Wrocław and the EU4 FAST project in the Western Balkans. In 2020, she was admitted to the list of attorneys in Lublin, in Poland, and since 2021, she has also run her own law firm specializing in criminal cases, human rights, and international criminal law. She is actively involved in the project Sunflowers, which collects information on international crimes committed in Ukraine and about victims of the war. She is also a member of the International Association of Penal Law. In 2024, she was elected a judge of the European Court of Human Rights as the first Polish woman lawyer. Congratulations, Anna, for this appointment. It was not very far away from this moment. And thank you very much for joining us. I'm sure it will be a great pleasure to participate in this meeting under your leadership. Anna, you have the floor. Thank you very much.
Thank you very much, Professor, for such a vast introduction, and thank you very much, Eva, for inviting me to moderate. I'm also happy to meet Mr. Osvaldo Giler online, but I also want to say that I'm really happy to see Evgenia Bondarenko, with whom I have been working for years in Ukraine, and we have conducted together so many webinars and seminars via Zoom that I'm almost missing this. I'm really happy to be here with you all. And from the very beginning, I want to invite you, all the participants, to be active, to put questions, to write your questions in the chat. And also at the end of our meeting, or important part of our meeting, it will be like a question and answer session. So then you can raise your hands and put your questions, especially that I think that we are meeting in a very interesting moment in the history. And I don't believe that Eva have predicted the development when it's come to the international law that we are observing now all over the world, that somehow undermines the fundaments and the ideals of the international legal order, which is based on the principle of the sovereignty of the state, and which is based on the principle of respect to the territorial sovereignty of the state. And this is what we will be discussing today. And I expect that there will be questions regarding the future, the perspective for the international law, for the International Criminal Court. Unfortunately, we heard about many repercussions or persecutions against judges, against the staff of the International Criminal Court, which is not like a good signal for the future. And as the title of our webinar indicates, cooperation between the International Criminal Court and the states is crucial, because the possibility to operate, the chance to work effectively depends fully on the cooperation with the state, with the states, with the member states of the Rome Statute. The court itself does not have tools, does not have enforcement power to proceed, to enforce arrest warrants, to collect witness evidence, to protect witnesses. And this is what will be presented by our distinguished guest in his speech. So now I give the floor to Mr. Giler, and I'm really asking all our participants to note questions, to note comments that you want to make, and I'm sure there will be opportunity to do so. Thank you.
Thank you very much, Dr. Adamska-Galan. Thank you very much for those opening words. I want to start by thanking President Hopmansky. It is always good to see you, dear Piotr, especially wearing a bow tie. I'm very happy to see you here in front. Thanks for the invitation. Dear Eva as well, thank you very much for your kind invitation. It is lovely to see you again. And of course, a welcome to all of the participants and dear colleagues. I want to thank you for the invitation to reflect with you today on the cooperation with the ICC, which I think, as it has been said, is a conversation that I believe could not be more timely given the state of the affairs today. Now, but before I turn to substance, allow me to begin perhaps on a more personal note, and which is particularly important given one of our hosts today. President Hopmansky knows better than most that the ICC is going through an incredibly challenging moment in its history. There are threats and attacks against the ICC, and these threats and attacks, as it has been said, they're not abstract. They're not theoretical. They're real. He himself, with 6 other judges and the prosecutor, has been subject to criminal proceedings by the Russian Federation and has been recently convicted in absentia in response to his judicial work in relation to the situation in Ukraine when president of the International Criminal Court. This has tangible consequences on his life, on the life of his family. It disrupts his travel, places pressure on him even after finishing serving as president and judge of the court. And this is on someone whose only offense was to uphold the law in the Rome Statute. And here we go back to the point of sovereignty. A law that has been sovereignly accepted by more than 2/3 of the countries around the world. And I begin here because I think this experience captures, in very human terms, the environment in which the ICC operates today. So the ICC is confronted with a heightened and unprecedented, what we can call threat environment. And I think it's one that directly affects its operations, its staff, its systems. So overall, it directly affects its ability to function. Criminal proceedings against ICC judges, sophisticated cyber attacks against our infrastructure and against our information, which includes information about our witnesses, our victims, evidence, unilateral sanctions imposed by one non-state party against individuals or officials of the ICC, and those who cooperate with it, by the way, not only ICC officials, but also those cooperating with the court. All of these things have fundamentally altered the reality of the court. There's not only one event, it's a combination of actions that are being undertaken. And let me be clear, these measures are not aimed at a legal argument. They're not aimed at a legal position. They're aimed at disruption. Now, the good news is that despite this environment, the court judicial work continues. Investigations are moving forward. Hearings are proceedings. Reparations for victims are being implemented. We have new cases coming into the court. So the work continues. And it is precisely because the court is resilient and precisely because the court continues to carry out its functions that cooperation, which is the subject of our conversation today, matters more than ever. At its core, the Rome Statute system is built on the notion of cooperation and trust between states parties, and the court. That is a foundational aspect of the system. Arrest and surrender, gathering evidence, witness protection, enforcement of sentences, this remain the backbone of international criminal justice. And without these actions, without this, the ICC can simply not deliver on its mandate. Here, there are important, I think they're important and encouraging developments that we need to look into. And let's look at just 2025 alone. In 2025, we had two cases that were in very different ways, in a way, two cases that are very different from each other, where two suspects were surrendered to the ICC just last year. The former president of the Philippines, Mr. Rodrigo Duterte, and Mr. al-Hishri for the situation in Libya. Very different. In one case, we have a non-state party surrendering the suspect to the ICC. In another state, we have a state party surrendering the suspect to the ICC. In one case, the non-state party had withdrawn from the court, and in another state, the jurisdiction comes from the Security Council referral. So there are very different cases. In the al-Hishri case, which the surrender happened on the 1st of December of 2025, this also marks the first successful surrender in the Libya situation since the situation was referred by the Security Council in 2011. Now, these outcomes, they're not the result of a single act, but they are the result of sustained and coordinated cooperation over time. That is demonstrated that when states act consistently and collectively, accountability remains achievable, even in complex political environments. But taken together, the Duterte case and the al-Hishri case, I think these cases also show us something important, and is that cooperation with the ICC is possible even across very different legal and political contexts. And accountability also does not depend on, and this is important, it does not depend on a single model of engagement. One thing the ICC has learned since its very beginnings is that cooperation looks different in every situation before the court. If you think of ad hoc tribunals, for example, normally over time, they develop cooperation models that are very suited to the context in which they operate, to the political and legal realities of the context in which they operate. In the case of the ICC, we have 17 situations under investigation, each one of them in very different contexts, each one of them with very different realities. Therefore, cooperation takes very different shapes, and we have to adapt to understand how cooperation would be possible in different places. Now, within the registry, what we have done is that we have worked on strengthening the internal cooperation architecture, if you want to call it like that, to support this kind of outcomes. So we have not only included this as a priority in our strategic plan, prioritizing, of course, strengthening political, financial, operational support to the court's ability to implement cooperation. But also we have created a new section within the registry, the Judicial Cooperation Support section, that is specializing in judicial cooperation with states parties. This is important because what we have seen over the years is that we need to adapt to the legal realities also of the state that we are asking cooperation. Asking freezing of assets from state A does not look the same as asking freezing of assets from state B. Asking for, especially when you start incorporating in the discussions, implementing legislation, we have seen how the implementation or the execution of legislation in the different countries takes different forms. And we need to be able to adapt to the realities of each country when we are submitting requests for cooperation and where we are executing them. But also advise the chambers, under which authority we operate, of course, how to best put forward requests for cooperation in different cases and in different situations. So this is part of the dynamic process of cooperation that we keep learning, we keep adapting, and we keep seeing. I mean, for example, the recent arrest in the El Hishri case, the surrender, was quite interesting because it was the first time that the legislation in Germany was being used. So it was being tested. So we saw and we were able to see what processes were necessary at the national level, how the national level was triggered, how the different parts of the government were triggered. And it was quite an exciting process to see this legislation in action and see how the different actors within the government were implementing it, in consistency, of course, with the Rome Statute and the request from the court. This is part of the dynamic process that we are constantly learning from. Now, in this context, the court continues to engage closely with key partners. We engage through bilateral operational meetings. We engage in expert roundtables. We engage with international regional forums. So we're always looking for ways of engaging to raise awareness, to create forums for discussion, identifying focal points, understanding how to best create the dynamics that we need to create, including issuing recommendations also for states parties on how to improve the ability of states to cooperate with the court. And these recommendations, I mean, we recently issued some recommendations on how to foster cooperation for the implementation of arrest warrants, which was recently welcomed by some of the states parties at this latest session. So that's mostly in relation to arrest, but there are other critical areas when it comes to cooperation. We look at, for example, witness protection and witness relocation is crucial for us. The judicial process before the ICC cannot function without witnesses who feel safe to testify before the court. Now, this takes different shapes and different forms, and of course, the highest form of cooperation in this case is allowing for the relocation of witnesses in the territory of a state party or a state. In many cases, the simple relocation of the witness away from the source of threat would be sufficient. So we don't need the person to go into a witness protection program. We don't need the person to be in a special regime situation. But in the vast majority of cases, just removing the person away from the threat allows us to deal with the risks. This is and here the type of cooperation that we normally are seeking in reality has more to do with immigration status or procedures like can the refugee convention be applied, can some kind of immigration proceeding be applied, and of course we accompany the case and we're always talking with states. And here we have experience where we have done this on the basis of very formal arrangements, where we have a very detailed pre-agreed process for requests, taking into account that in the case of witness relocation, states always retain discretion. So this is not something that we can mandate states to do. They will always retain discretion to say yes or no to any suggested relocation. But we have also done it on the basis of very informal arrangements, very flexible informal arrangements on a case-by-case basis sometimes, or ad hoc arrangements. In reality, in practice, we have fewer than 20 states that currently assist the court in the area of witness protection or witness relocation. But there's one important gap, which is particularly, I think, pressing here, which is when it comes to insider witnesses. So witnesses that are sometimes part of the criminal environment. These witnesses, as you know, they are critical for the prosecution of cases. But there are many considerations here. So, for example, in these cases, the level of risks tends to be very high for insider witnesses. They may require additional forms of protection. So it's not only a relocation, often, I mean, depending on the situation as well. And normally they will fall outside, for example, the refugee framework, because they wouldn't be able to meet some of the conditions. Here, I think in this case, this is where normally national witness protection programs would be the best equipped to deal with this kind of witnesses, which are, in our experience, the most difficult to get cooperation for, but at the same time essential for the prosecution cases. Now, another aspect that is also very important, and is not directly related to cooperation, but is indirectly related to cooperation, is complementarity. Because when national jurisdictions investigate and prosecute atrocity crimes, they also reinforce the entire system, and it makes cooperation easier. So when you're dealing with a country that is also investigating, that is also looking into atrocity crimes that the ICC is also looking into, this reinforces cooperation mechanisms. And we have had a lot of experience in this regard. For example, even with the situation in Ukraine, where we have been able to work together very closely with authorities there and receive a lot of cooperation for our different requests. One example also that I want to highlight here is the Beina case. The Beina case in Central African Republic. Now, here it was a case of a warrant of arrest in the Central African Republic of the International Criminal Court that was executed. So at the request of the court, the suspect was apprehended. But once the suspect was apprehended, it came to light that the suspect was also being sought by the special court in CAR. And after a procedure of admissibility before the judges of the pretrial chamber, it was decided that the case can remain in CAR. So we see also here how cooperation with the ICC and complementarity can work together. I mean, yes, it's true that the arrest was effectuated on the basis of an arrest warrant by the ICC, but ultimately it was decided that the national special court was equipped to deal with the case against in case of this suspect. Now, looking ahead, also we need to consider how instruments like the Ljubljana-Hague Convention, for example, also promise to further weave the global fabric of accountability and could create a framework or a context that enables cooperation for atrocity crimes more mainstream or more systematic. We have also worked in broadening our partnerships to achieve cooperation, of course, with the UN, also with other accountability mechanisms. So as you know, the UN has created also different types of accountability mechanisms. Sometimes we have overlapping interests, sometimes we have overlapping capability requirements. And this is where we have looked into how to broaden that cooperation, that engagement with regional organizations, but also with non-state parties, because some non-state parties are interested in cooperating on specific situations, and we are seeking those opportunities as well. Especially because recent judicial developments have opened, I guess, new avenues of engagement in regions that previously were a little bit more distant from the court. Each new cooperation, however modest, helps to normalize the idea that international justice is a shared responsibility. Here I also want to mention other actors like academia, universities, legal communities, bar associations. These are essential partners. Academic institutions, associations, civil society actors, they sometimes are the ones opening the doors where the political engagement is being more cautious. And this kind of conversations allow that kind of opening of pathways that sometimes without these actors speaking up, they would not be possible. Now, all of this that I've just spoken about, I guess, reflects on what we might call traditional forms of cooperation, what we traditionally understand cooperation, which is basically cooperation understood as the enabler of the judicial process, as the enabler of the judicial mandate of the court, which of course is indispensable. But in the environment in which we're operating today, cooperation needs to take an extra step. It has changed. Because today, the ICC's independence can be undermined without even touching a single judicial decision, but by simply targeting the court's operations and the lifeline of the court. For example, when a non-state party threatens to unilaterally and extraterritorially sanction the court, banks, insurance companies, service providers, IT service providers, they comply. They suspend services to the court. That means the court can no longer pay for its operations, can no longer pay its staff, can no longer rely on secure systems for its activities and its information. As I highlighted at the beginning, today we have 11 officials unilaterally sanctioned by the United States. 8 judges, the prosecutor, and the 2 deputy prosecutors have been individually sanctioned. This is in addition to civil society organizations and a UN representative, a UN mandate holder. These are all sanctioned under the executive order sanctioning the ICC. For this reason, we have to understand cooperation today, not only as a way to ensure that the judicial process before the court can go ahead and can be executed, but also as a way to protect it. So we call it protection as cooperation. Now, protection as cooperation is not a new legal obligation. It's more the strategic evolution of whatever existing duties already are contained in the Rome Statute. Because if you go to the essence of the obligations of states when it comes to cooperation with the court, it is the most essential obligation of states parties is the obligation to ensure that the court can act independently, effectively, and without interference. So put simply, this asks the question, how do we ensure that no external actor, state or private, can prevent the court from functioning by applying coercive pressure? Now, in practice, this means several things. It means legal institutional protection. For example, by fully domesticating the agreement on privilege and immunities of the ICC, by adopting measures that shield the treaty obligations that states have with the court from the coercive measures, by providing legal certainty to the service providers, to the banks, to the insurers, that they can continue working with the court without fear of repercussions. It also means financial continuity, of course, and this something like this sounds quite basic, but paying the SS contributions in a context of sanctions, this may not even be possible for some states. But paying SS contributions, ensuring that the banking system at the national level remains accessible to the court, supporting ways in which the court can securely pay salaries, our field operations, our field offices, and all of our operations, of course. It also means operational and technological resilience. We need to be more integrated into national cyber defense frameworks. We need to be giving support on sovereign or regional hosting solutions for IT services, facilitating travel and movement of individuals throughout the world. So in moments of pressures, what we have seen is that state-backed or state-owned entities have proven to be decisive in maintaining the continuity of the court and the autonomy of the court. If you think about especially tech autonomy from this point of view.
I'm afraid that we have a problem with connection, or is it only me?
No, it is a problem, I guess.
Yeah.
We all seem to have problem. Just stopped.
Yeah, just stopped. So we will wait this few moment. I hope that Osvaldo will manage to join us.
I'm not sure whether he's aware, you know.
Because he seems connected still, I believe.
I will try to text him. Piotr, maybe you can text him.
Let's just wait a few moments, because I think that he disappeared now, so he should be aware that he's not connected. Zhenya, if you see him in the waiting room, maybe already. No,
not yet. I'm keeping an eye on it.
Yeah, so we will. Actually, my first impression from the first part of this presentation of Osvaldo was kind of optimistic about this operation, continuity of the operation and resilience of the court. Now he started to talk about this kind of very, I would say, practical aspects of the possibility of the court to work, and he was interrupted. So let's wait few moments for him to join. To connect, to write to Osvaldo.
I am afraid that his mobile is off. I don't see him.
Perhaps then, waiting for him, we can already invite our participants already now for the discussion and for comments. If anybody of you has already now something to raise, you know, I will start perhaps as using my position as a moderator, because you know I was wondering what impact the situation with Maduro can have on the operation or on the system of accountability before the ICC, because you know it's like thinking loudly. Perhaps this experience, let's call it this way, of Maduro, who was objectively kidnapped by US forces to be brought before American court, would serve as an for other potential accused to surrender themselves before the ICC, instead to wait, you know, for being kidnapped by somebody. But maybe it's kind of optimistic approach. Would anybody like to comment or to share their thoughts?
if I may, so I try to ask. So it is, it's quite specific situation because, you know, Maduro was not wanted by the ICC. There's no arrest warrant against him. So far I know. Of course, it could be also something confidential, but I don't think it would be the case. So that for him was not a choice, not a choice. Well, you're right that the situation of Philippines in the Maduro case is very specific because this is the case which shows that the only fallen regimes can be tried before the international court, which is something what we wanted to avoid discussing this issue in Rome in the end of the last century. The idea was to create the court for the future, to create the court who is not politically depending on states and the persons need to be tried regardless of the political situation in the country. But the reality is quite different. You see that there's no chance to try someone from Israel or someone from Russia as long as the conflict is continued. So purely because of the political reasons, and as long as Maduro was in power, it was completely not possible to expect that he would be surrendered to ICC. So I think that the lesson learned from this situation is that where the regime still is in power, there's not the issue of the choice where you can be tried. It's simple. They simply will believe that as long as they're able to keep the power, there's no chance for anybody, including the international court, to catch them and to try them. So it is not optimistic, I know. But I think it is exactly the case. It means that we have to wait. The international justice needs to wait as long as the power is kept by the perpetrators.
Yeah. Thank you very much, Professor. I just see that Osvaldo has joined us, and and I see the questions. We will return to them later. Just to Osvaldo, you know, whether the fact of Maduro being kidnapped would be like an incentive for other potential accused to surrender before the ICC to avoid being kidnapped. It was kind of a provocative question, but we are giving the floor to you, and we are happy to have you here back.
Thank you very much. I'm actually very happy that President Hovmansky was able to answer that question, and I don't have to answer that question right now. Sorry, I apologize for the technical glitch. I hope it was that, a glitch. Listen, I was coming to the end of my presentation anyway. What I wanted to conclude, maybe just to say, is that what is important for me to see is this overall cooperation, protection of the court needs to be seen also from the perspective of the cooperation. Because by protecting the court's ability to operate, we, of course, will ultimately also ensure that the ICC is able to execute arrest warrants, that ICC is able to protect witnesses, that trials can be conducted in an environment where the court is not constantly fighting for its own survival, rather than focusing on judicial mandate. Now, what this tells us, perhaps, is simple but profound, and is that the ICC is not being challenged; it is being tested. So it's not only being challenged; it is being tested legally, politically, financially, operationally. But it's also important to know why is it being tested? Why is it being challenged? Why is it attacked? Why are its judges facing criminal charges? Why are its officials being sanctioned? Why is it being threatened with sanctions? And it's because we're relevant. Because it is simple. If what we did didn't matter, or didn't have an impact, then we wouldn't be sanctioned. We wouldn't be attacked. We wouldn't be coerced. Ultimately, our relevance, our impact, and our effectiveness depend on whether cooperation is understood in this full meaning, not only by helping the court to act, but also by ensuring that it cannot be prevented from acting itself. Thank you very much. With this, I think I will open the floor for any questions. Thank you.
Thank you very much for this concluding remark regarding relevance of the International Criminal Court and the reason why it is being attacked. Yes, as we have said, we are opening the floor for the discussion, for questions, and I saw the first hand raised. It was Miss Susanna, and I have a problem. Yet, is it still valid, the question? I believe yes.
Maybe I just wanted to contribute to your question about the Maduro case, but if you think we have moved forward, I can just skip my question, so feel free to.
I believe that we can. Please share your ideas or your impressions on this, I think, interesting topic.
So, Susanne Nothaft, I'm joining in from Munich, and actually my perspective on the Maduro case is a different one than you, even if your question was a provocative one, because what I fear is that it just curbs legitimacy from the ICC, because we all know United States did not snatch Maduro because they were upholding the rule of law, but they're just trying to get another idea of a hemispheric law made by power, by blunt force. So I think it is, in the end, probably more delegitimizing the ICC, because other states could even think that they will choose a similar proceeding. So I would say we are getting in muddier waters after that engagement with the United States, and I'm not hoping, but more fearing for the ICC after that January 3rd stint that they actually pushed forward. So I have a different opinion to your perception here. That was just I was adding.
Thank you very much. I saw one more hand being raised, but I'm not sure if it's still.
Yes, I am.
Yes, please.
Thank you very much. Thank you very much for a nice delivery and for invitation. I actually had a question regarding that specific situation with sanctions, with absence of like differentiated sanctions in the statute, because we know like most states, they prefer to have, they usually have, if they use on one hand ordinary crimes, yes, then we are talking about like responsibility for even for international crimes, or like another option, it's in regard of complementarity actually. And another option is actually to include the specific norms regarding international crimes into national codes. And that's actually, for me at the moment, that looks like a challenge, because on one hand, that we're talking about complementarity, we mean that so national, on national level, there is like unwillingness or not possible to do that. And the question is actually how to decide, how to do that in terms of like human rights, even when we are talking about accused, because in Rome Statute we have very general like norm regarding what punishment can be, and that is very general. And then we are talking even, for example, about Ukraine. We have like crimes against humanity now, we have war crimes, we have genocide. So we have several norms, we have several articles, which has, each of them has separate sanctions regarding these international crimes. And the question is actually how we can, is it, well, what do you think? Is it like a shortcoming in international, that is like a flaw, defect in international, in our own statute? And because this is very, like very uncertain regarding, then we should consider then the state is actually unwilling and then International Criminal Court has to intervene and has to, regarding in this question of complementarity. I hope that I formulated my question clearly. Thank you very much.
Thank you very much for this question. It was kind of combined question, but Osvaldo, I would give the floor to you.
Actually, the question, very generally, we can formulate it in a way that in Rome Statute, there is no different sanctions regarding this full category of crimes. We can say they are all international crimes, so they are all the same regarding their seriousness, their gravity. But I think most of experts, they do agree that they are not the same. They are different.
So I think what I was trying to say when I was mentioning this convention is that it furthers the system, it broadens the system, and it allows for a more mainstreaming of cooperation among states on atrocity crimes, on the investigation and prosecution of atrocity crimes, which ultimately also benefits the ICC, who will be eventually also the recipient of that cooperation. So the more this is mainstream, the more this is homogenized in a way, the more there are treaties that allow for this normalization of this type of cooperation, the more it benefits the system as a whole, including the Rome Statute system.
Thank you very much. Are there any more questions or comments from our participants? Eva, yes, please.
Yes, I have a question. Maybe not about the cooperation between the states and the court, but Osvaldo, what do you think? What can civil society organizations do to support the courts, in addition to our appeals and open letters to decision makers, urging them to unconditionally support the court? What else can we do?
So I come originally from civil society, as you know. I worked for 5 years in the coalition for the ICC, so I have a lot of experience on how civil societies form support, like I said, for the basis of support for the court. Look, it's a very important question, the one that you're asking, Eva, especially at this moment. Of course, there are different layers, right? And we can basically, virtually every aspect of the work of the court is subject to some kind of support by civil society organizations. From the more political level, like the one you just mentioned, creating pressure, advocating, lobbying on behalf of the ICC. I think this is very important. Often also civil society organizations are closer to national regional bodies, and they would have ways of advocating in ways that are much more relevant or directly attached to issues according to the national discourse. So they become very relevant interlocutors when it comes to the political level of support. I have seen how they also have dedicated expertise, depending on the different issues, and that expertise sometimes is translated into advocacy that is very helpful. But it also trickles down to the more operational types of support. I mean, we cannot function without civil society organizations helping us to communicate on the ground with affected communities. They have expertise on the ground. They're able to identify victims' communities, and they're able to help us identify affected communities in a general way. What are the concerns? How can we improve our communication about what is happening in the court? Also in identifying victims, for example, to participate in proceedings before the ICC, but also in identification of beneficiaries for reparations afterwards. It has been crucial for us to count on the support from civil society. I know the Office of the Prosecutor relies a lot on civil society organizations for the purpose of their investigations, to understand criminality, to understand what is happening on the ground. Just to say, a legal representative for victims, in general terms, civil societies are crucial for the work of the court. They are enablers of the court. Now, the bigger risk that we have is that we have now seen that 3 civil society organizations have been sanctioned because of their support to the court. And what this is creating, and this goes back to cooperation, is a chilling effect. Because right now, we're not only talking about the normal challenges that cooperating with the court has, But we need to add to this now a chilling effect from civil society in cooperating with the court, because materially supporting the ICC and the efforts of the ICC can lead them to being designated themselves. And we have seen this already happening, where some civil society organizations are taking a more cautious approach when it comes to engaging with the ICC as a whole, across all situations.
Mm-hmm. Thank you very much. Yes, please. Yes, please.
May I also contribute, even if the question was not addressed to me? Is it okay?
Yes, please contribute. Yes, of course.
So I think the crucial part civil society can play is giving agency to survivors. And this, I think something really, the outreach structures of the ICC, they are in place, but they are sort of a structure, and it will not be sufficient. So if I, as a local community over NGOs, being able to really make survivors foster their agency, then it gives probably also some effect, even if a proceeding is not ending up in an effective sentence, because the right to truth and the right to sort of tackle human rights violations on a large scale starts with engaging with the victims. And I think this is crucial what civil society can contribute. Nevertheless, how the ending before or at the ICC ever will be in the future. And this might be maybe the most important contribution civil society can do, engage with the victims, whatever the outcome of the ICC proceedings is.
Yeah, I think that this support for the victims, giving the forum for the victims to speak is extremely important. This is also underlined by one of our participants in the chat, a Rohingya refugee. She wrote her story in the chat that we can all read. And she's underlying this importance of accountability and dignity for people who have suffered for too long. I will also read the question from the chat from Zlata Savertak, and the question is about 2025 cyber attacks against the ICC. In your opinion, how can the court ensure the chain of custody and integrity of digital evidence collected from social media or encrypted communication in conflict zones?
Okay, so thank you for the question. Very relevant. I've been discussing a lot about cyber attacks lately. So the reality of the court today, if we look at the type of cyber attacks that we are normally subjected to, they don't tend to be of disruptive nature. They rather tend to be of espionage nature. So what we have is very sophisticated actors with state-level capabilities that are trying to infiltrate our systems to understand what we're trying to do. So they want to know. They want to know what evidence do we have. They want to know what information is out there, is in the possession of the court, in order to understand and keep monitoring this. And what we have seen also with our attackers is that there's an intention of persistence. And persistent attackers, they want to stay in the system. That's what they ideally would like. So they tend not to disrupt. That's one thing. Now, none of the attacks that we have suffered so far have, let's say, touched on the crown jewels, what we call. So the evidence vault, in a way, like the more the core information about the identity of witnesses or evidence that is within the judicial work. So that's not been an issue right now. Of course, if this was to be an issue, it will have to be looked into judicially, and it will be up to the judges to determine the admissibility of the evidence, depending on whether or not it has or not been corrupted. But it hasn't been an issue for us right now. Maybe that answers the question.
Thank you very much. Are there any more questions? Any more comments? Yeah, Professor Hofmeister.
Thank you very much. I have the question is, in fact, a little bit of the political nature. But as we know, the states parties are not really very keen to cooperate. We have a lot of cases that the state parties refuse to cooperate. And what I am afraid that in the current political situation in the world, the big players, they try to sanction illegally the court, also make the huge pressure on other states to discourage them to cooperation with the court. And this is something what I'm really worried about, because and this is basically my question. Is there any risk that, for example, the Washington will also see the readiness to pay contribution to the court as the form of the support for the court, and the opportunity to sanction those who is ready to pay the contribution to the court? And we all know without the financial contribution, the court will simply die very soon. So how do you see this situation, the risk? I try just to describe in a few words.
Thank you, Piotr. You're asking me a very difficult question, and because it forces me to speculate a little bit. But what I can say, perhaps without speculating here, is the executive order, in this case, sanctioning the ICC. It's called sanctioning the International Criminal Court, imposing sanctions in the International Criminal Court. That's the name of the executive order. So there are different activities that are in a way not allowed by the executive order, including providing material support to the court. Now, this is a very vague material support to the court, and of course, we need to see how this is continues to be interpreted. So far, for example, it has been interpreted in relation to 3 civil society organizations and a special representative of the United Nations that have been engaging with the ICC. Now, there's a lot of discretion from the side of the US in interpreting its own executive order. So I don't know exactly to what exactly they will consider to be materially supporting the work of the court and what not. And of course, we have different ways of assessing risks here, and what can be more reasonably considered and what cannot be. So we have developed some kind of understanding about the different risks. But generally speaking, I don't know what exactly would be considered material support to the court. Now, as states parties paying contributions, of course, I think there are different challenges to that. And if the ICC was to be designated, for example, it would already be, just by virtue of it being designated, it would be difficult for banks that the states parties use themselves to process the payments of contributions, because they will not want to pay, they will not want to transfer money to a sanctioned individual, which is also one of the prohibitions under the executive order. It's providing funds, assets, or services to a designated entity or individual. So all in all, to say yes, but at the same time, I think that we also have to look at this from the point of view of the incompatibility of these sanctions with the existing obligations of states, and the obligations that not only exist by virtue of the Rome Statute, but also the Agreement on Provision Immunities or the Headquarters Agreement. So if there is an incompatibility, well, we cannot, I think the wrong way of looking at this would be from the point of view of the primacy of unilateral sanctions over international law. At the end of the day, what we have to be able to do is uphold international law, international obligations of states over the unilateral coercive measures applied against the court. And this is what I would hope states parties continue to do, as they have been doing so far. Thank you.
Yeah, when we talk about the sanctions, I'm not sure if you read about the statement of the president of the Court of Appeal in Paris, who commented on the allegations that the sanctions may be imposed on judges who sentenced Marine Le Pen. So we are kind of living in a completely strange world with less and less predictability. Something that was completely unimaginable is being already commented officially by the presidents of the courts in certain countries.
But this is also not theoretical. It also
Yeah.
happened in Brazil. Brazilian judges have
Okay.
actually been sanctioned by the US already. So it's
I did not. Yeah, I was not aware of this. So this is, yeah, like it seems like a pattern now already, almost. Unfortunately, I see Madame Susanna raised hand.
Maybe just a short remark. My fear is that as long as we don't change the architecture of the United Nations Security Council, it will be hard to transfer, especially the crime of aggression, to the ICC. So I think it's a broader issue, actually, maybe rethinking the international law architecture, because we are living in times where realpolitik, hemispheres, lager politics are getting more and more implemented, and that has reverberations on which crimes, which states, which persons were referred to the ICC. So I think the problem is a deeper and bigger one, actually.
Yeah, thank you very much. I think that this what we are observing. It's like a new world order is being brought to life, and nobody knows what will be the outcome of this. Any more comments, questions? I see. Yeah, importance that such a court is important for accountability. And I think that the very important conclusion is that there must be a political will always to support existence and operation of the court as the International Criminal Court and or all other international courts that operate in the world, I would say, including our court in the European Court of Human Rights. But it's for another webinar, I believe, the discussion about the challenges that we are facing. So I believe that we can conclude perhaps some final remarks to Osvaldo, Piotr Hofmański and Ewa Hofmańska to close the webinar.
I mean, maybe thank you very much. Just to thank you all again. Sorry for the technical disruptions, but it was a very important conversation. I know Piotr has been recently in a pessimistic mood since I saw him last time in Nuremberg. But I think we have to be optimistic. I don't think there's any way we can do our job and not do it with hope, because otherwise there's no point in the job that we're doing. I'm very encouraged by this conversation at the beginning of the year that already comes with its own different challenges. And thank you for listening. Thank you for the support. Just to reassure you that the ICC is resilient. We are continuing, and our work continues. Thank you very much.
Thank you very much, Osvaldo. Professor Hofmański.
Thank you, Osvaldo. Thank you very much for the time you have taken from your busy schedule. I know how busy you are, how many challenging before you. I know that this is a difficult period also for the ICC now, and also for you as a registrar of the court. So thank you very much for being with us. I think it's the really beginning of the discussion. It's not possible just to manage all the issues in the short 90 minutes, even less. But anyway, thank you to all the participants for being with us today. And I would like just to thank for our partner, Foundation Sunflowers, for the cooperation and for the organization of this webinar. I'm sure that's not the last one. We will make other events together. Thank you very much. Good night.
Thank you very much, Professor Hofmański. Ewa Hofmańska, she already said that this is the first in this year, so the year already only started. So I believe that there will be more and more. Ewa, please.
What can I say else? I would like to thanks again to everyone who could contribute this meeting. I think that soon the recording will be available on our website and also at the Kraków Center website. So please follow our websites and our social media. Thanks again for this great discussion. Thank you.
Yeah, so just to close up, thank you very much. Thank you, Evgenia, for your help. And we will do our best that during the next webinars, these kind of situations will not repeat. It's always like a technical issue. So we'll try to find a solution. Thank you very much. And I wish you all that this year is become less interesting with time than it is now.